Who gets the house in a Massachusetts divorce? Your house is probably your biggest asset. It is for most people. Beyond the financial importance of your house, there are strong emotional ties to your home. It's where your family lives their lives, where your children sleep. That's why it is so difficult to decide who gets a house in a divorce. The first thing that must be analyzed when deciding who keeps the house in a divorce is, when did you buy the house? If you bought the house before getting married, it may not be considered marital property. It could be considered separate property. If it is separate property, generally whoever bought the house keeps the house, although that's not always true. But it isn't always easy to determine if it is marital property. Even if you bought the house prior to the marriage, a court could still decide that it is divisible. The court will look to see if the home has increased in value during the course of the marriage, if the non-owning spouse helped to improve or maintain the home. Did that person pay for a new roof or a new heating system? Or if the non-owning spouse, if their funds were used to pay the mortgage. If you used funds you had prior to the marriage to pay for a down payment, you may receive credit for that, even if the property is considered the marital home. Who gets to stay in the house during the divorce? A common question is, can I kick out my husband or my wife from the house while the divorce is pending? A family and probate court judge can order one party to have sole use of the marital home during the course of the divorce. These situations are usually reserved for instances of domestic violence and/or restraining orders. Also, a judge can order one party to leave the home if there is a danger that you or your children will be harmed. Awarding the house on a permanent order. Awarding the home to one party or the other is usually the biggest property division issue in a divorce. In making that decision, a judge will look to several factors, including the length of the marriage, the conduct of the parties during the marriage, the age and health of the parties, the occupation and income of the parties, the opportunity of each of the parties to earn income, the present and future needs of children, the contributions of the parties to the home's acquisition and preservation of assets as a homemaker. Let's take a look at some of these factors a little more closely. Conduct of the parties during the marriage. A judge may consider how each spouse acted during the marriage when awarding the assets. Those actions could have affected the marital estate. For instance, if one spouse has a gambling problem and lost a lot of money, if one spouse gave away assets without the other spouse knowing, or if one spouse contributed more to increasing the marital estate. The age and health of the parties is also a factor. The age and health of the parties to a divorce can have an impact on how property is divided. If one party is older or in poor health, that may prevent them from being able to acquire property in the future. Therefore, a judge might lean their way when awarding the marital home. The needs of the children will be examined. Who gets the house in a divorce with children? A court will consider the needs of your children when awarding a marital home. Judges want to keep the children in their home, if at all possible, so as to avoid any additional trauma. So whoever gets custody of the children will have an advantage in getting awarded the house. The divorce court can order a deferred sale of the home. This allows the children to stay in the home until they reach a certain age. Although possible, deferred sales are rare. Basically, there are 4 outcomes when dealing with dividing a marital home. First, one spouse buys out the other. Number 2 is the house is awarded to one spouse or the other. Number 3, you and your spouse continue to own it jointly, or you can sell the house and divide the proceeds. For financial reasons, selling the house is the most common. Whether or not one spouse can buy out the other's interest in the home depends on each party's financial situation. Anyone buying out the other must be able to come up with the funds to do so. That person typically has to get a mortgage in his or her own name, which is oftentimes difficult. Very often, two people have to be on the mortgage in order for them to qualify. If one party is awarded the house, there will likely be an offset. An offset means that since that spouse received the value of the equity in the home, the other spouse should receive more from other assets. That's assuming there are enough assets to cover such an offset. Let's take a look at what happens if you sell the house. If you sell the house, several obligations must be paid, including the mortgage, any home equity loans, the real estate broker fees, closing costs, and taxes. Any equity in the home will generally be split between you and your spouse. Because Massachusetts is a community property state, the split does not have to be 50-50. It must be equitable, fair, in other words. The court will look to several factors in making that determination, such as who contributed toward the purchase and maintenance of the home, how are other assets being divided, were there any liens on the house attributable to just one party? What if you have to sell a house in a divorce and there's no equity? You may have to sell the house at a loss. That is to say, you owe more money than the house is worth. In that case, the debt needs to be split. That could be an even split, or one party may take on a greater portion of the debt than the other. In conclusion, dealing with a house in a divorce is complicated. There are many factors that must be taken into consideration. The fact that it is usually the most valuable asset, coupled with the emotional ties to the home, make this issue particularly thorny. You should certainly consult with a qualified, experienced Massachusetts divorce lawyer for advice. Please feel free to visit us at affordlaw.org if you have any questions about this or any other family law or criminal law questions. We offer our fees on a sliding scale, which means the less you make, the less you have to pay. It's very important to be represented by an attorney in a divorce proceeding. At affordlaw.org, we are making justice affordable.